Hi, this is Anthony Parent of IRS Medic. FBAR penalties are something that are incredibly ruinous. And if you are a student of the law, one of the things that must interest you is the authorizing statute for FBAR penalties and how vastly different it is from the regulations. In fact, my guest John Richardson and I have been discussing this for years, and the conclusion is that there is no FBAR law, but rather the FBAR is something that simply springs from a regulation. That regulation itself, and I'll share my screen right now. I'm going to go over to that right now, and that is at here. Let me see here. I'll get my screen up here, and that is, so here's the regulation, the FBAR regulation. This is what says you have to file a foreign bank account. Report on your foreign bank account, or else it says each United States person having a financial interest in or signatory or other authority over a bank, securities, or other financial account in any foreign country shall report such relationship to the Commissioner of Internal Revenue for each year in which such relationship exists, and shall provide such information as shall be specified in reporting form prescribed under 31 U.S.C. 5314 to be filed by such persons. That goes on to say the form prescribed under 5314 is the report of foreign bank accounts, financial reports, or on any successor form. We're going to move over to this. Now I'm going to move over to the section 5314 so that you can see the complete absence of any prescription for an FBAR form. Here is the law itself. This is the law that is claimed to require an FBAR. It actually doesn't really mention anything about foreign bank accounts, in fact. It really doesn't. It mentions something about a foreign financial agency, which the law defines as a relationship with another person. So the law itself says nothing about reporting an FBAR, and that's been my argument is this isn't even close, that we have a regulation that kind of contradicts the law, that this law actually requires the Treasury to collect reports of foreign agency transactions. And what we have is something different. No, this is now a law that individuals must file reports of foreign bank accounts or ruin everything. If we look at the law to say, okay, what kind of penalties are we talking about here? Not a lot here until we go to another section. So now this has been my argument, but then John Richardson pointed something incredible out to me that no matter what, I could be right or wrong, still might not matter. John, what's going on with section 5314? Who has the requirement?
Yeah, okay. So the bottom line is, let me start with a conclusion and then we'll backtrack a little bit. But the bottom line is that 5314 imposes an obligation, a requirement on and only on the Secretary of the Treasury. Okay. I mean, sure, there's a lot of text there about what it is they're trying to do, but what it is really saying is that Congress is requiring the Secretary of the Treasury to create a series of regulations and a form designed to force people to basically report foreign bank accounts and other things. Okay, but I don't want to complicate this too much. So you look at all that text in there, all right, and the part that matters is, the part that imposes an obligation on anybody is the Secretary of the Treasury shall require a resident or citizen of the United States. The Secretary of the Treasury shall require. In other words, 50, and this is important, 5314 imposes no requirement whatsoever on any individual. It imposes a requirement on and only on the Secretary of the Treasury. And I think that's incredibly important. We've talked about, yeah. And of course, now the way the Secretary has responded to that has been by creating the regulation that you had up at the beginning of this podcast.
Here's the regulation.
Yeah, it's right here. But also, just pause there for a minute. Notice that the regulation lays out the general principles here. But what it says is that right up there at the top in general, okay, it says shall provide such information as shall be specified in a reporting form. Specified in a reporting form. So what's happening here is that not only is the regulation what requires people to do this, but it seems that the content of the reporting form itself has that same status as well. So the bottom line is that 5314 imposes a requirement on and only on the Secretary of the Treasury to do this stuff. Now, what happens? What happens if somebody doesn't comply with what the Secretary wants? Well, what's fascinating here is that the penalty provisions, we need to go back to Title 31. So if you could go back to Title 31.
I am right there. I'm on the civil penalties.
Who could have known? Who could have known? All right, now, there are two kinds of penalties. All right, the first would be the civil penalties, and these were introduced in, I think, 2004. And the second is the criminal penalties, which have always been there. Right. Now, I want you to notice something. Let's start with the criminal penalties, actually.
Yeah, I think you're right on this, because this really, this lays it out. I think this beautifully lays it out.
Okay, move up to the top if you would. Now, basically, if you look at A, B, and C, you'll notice that these say a person willfully violating this subchapter or a regulation prescribed under.
Let me underline that. That is so key right there. Or a regulation prescribed.
That's right. So the criminal penalty section, all right, specifically says that if you violate a regulation, then you're caught by this. Now, I'd like you to go to 5321.
Okay. Yeah.
Now, let's look at
now we're back, and again, we're back at the civil penalties, which
move down, though. We're talking about FBAR. Move down, please, to subsection 5. Stop there. Stop there.
Yeah.
Okay. So this is for the foreign financial agency, which is the FBAR.
Right.
Now let's read this together, and let's read it slowly and try to make sense of it.
Yes.
So let's imagine that we have somebody who has violated the FBAR obligation prescribed under the regulation. Penalty authorized. Okay. Now it says the Secretary of the Treasury may impose a civil penalty on any person who violates or causes any violation of any provision of Section 5314. Okay, forget the amounts or anything for a minute. The Secretary of the Treasury may impose a civil penalty on any person who violates or causes a violation of what? Any provision of 5314. Okay, so you ask yourself, well, so the Secretary of the penalty is imposing a violation on a person who violates 5314. But if we go to 5314, 5314 imposes no requirement whatsoever on any individual but the Treasury Secretary. And the specific requirement given to the Treasury Secretary is to create the regulation. So presumably, if we go back to 5321, a violation of 5314, wouldn't that have to be either the Treasury Secretary doesn't comply and doesn't create the regulation, or some nefarious third party comes in and interferes with the ability of the Treasury Secretary to create the regulation? I mean, isn't that what it actually says? Yeah,
that's exactly what it says.
Yet, if we look at cases like Bittner, Toth, you know, this recent, Flint Jones, and so many others, clearly the assumption is that 5321 reads and says that Treasury can impose a penalty for violating the regulation. But the problem is here, as I think you see, Anthony, that the violation of 5314 does not, in its plain terms, apply to an individual, right, other than the Treasury Secretary. So I'm not sure what's going on here, and I've never seen that observation anywhere. I'd sort of.
Well, I see it as I think another way to restate it is that there is no law that allows civil money penalties on a violation of 5314. So in all these cases, can the government show that any of these people violated 5314? Now, again, it can be someone other than the Secretary of Treasury. If it's somebody who's frustrating it, then sure.
What is it they're frustrating, Anthony? What they're frustrating is the capacity of the ability to create the regulation and require the reporting, right? I mean, that's what it would be. Now, I am sure that I must be wrong on this for the very simple reason that, I've never seen anybody, make this observation before. But, those of you who know me know that I tend to, think it's a good idea to look at what the law says if we're talking
what
about
it actually says here. Wow, and it's specifically, and when you look at and it's wonderful that the criminal violations show they knew how to write the law to mean any regulation. Mm-hmm. They didn't include that there, and now you want the same law, even though it doesn't say that.
That's
it doesn't say civil penalties for any regulation under the statute. It says violations of the statute, not regulations under there. It's the violation of the statute.
Well, it's more than that. It's violating the provisions of that particular section of 5314. But again, 5314 imposes no obligation whatsoever on any individual. It imposes an obligation on the Treasury Secretary. So,
all right. Well, let's
look at, for example, Bittner, right? And the issue the Supreme Court is looking at as well. Is 5321, can a non-willful penalty be based on per account or per form? Perhaps another question is whether a non-willful penalty is even possible under the existing legislation.
I don't think it is. No, right. And I mean, and here's the other ridiculous part of this is sort of always the thing I bring up with all of these great appeals officers and brilliant people at the IRS who truly are on the side of truth and justice. The thing I bring up to them is this. I say, well, look, your statute yourself. Like, okay, you guys spell it all out. Okay, Schedule B of someone's tax return alerts them to an Fbar, and then the Fbar alerts them to the regulation, which alerts them to the statute. Well, what if someone goes and does all their work? They're like, well, you know what? Schedule B alerted me to the Fbar, which alerted me to the regulations, which alerted me to Title 31, which alerted me to 31 U.S. Code 5314, records and reports on foreign financial agency transactions. Reading this entire law, I said, this doesn't apply to me because I have a foreign bank. I don't have a foreign agency transaction. You would think, this is my point, is that you would think reading the statute would provide a reasonable cause defense when the regulation is wildly different from the authorizing statute. Again, let's assume that they can make it anything they want. But still, doesn't that go to, well, we don't know what magical things are in your head because we go by laws to determine what the law is, not what you're feeling today with your press release.
Okay, so let's be careful not confuse the issues here. All right, so one issue where we seem to have gotten into now is, what happens if somebody violates the regulation and does 5314, have the legal authority to create the regulation? I think it probably does. But here, I know you don't, but that's okay. But the point I want to make here is, what if you violate the regulation, right? Does 5321 operate to give them the authority to impose that kind of penalty? And it doesn't seem to me that the plain wording of the statute allows it, for the very simple reason that 5314, whatever it says or doesn't say, it clearly does not impose a requirement on any individual here. It imposes the requirement only on the Treasury Secretary. So,
right, John, I think I want to drop up here. We're short on time, but this is what I think we could conclude with and ask for help from our terrific audience. So my argument would be this, that in a post West Virginia versus EPA landscape, that if we look at 31 U.S.C. 5314, the Supreme Court would rule against the regulation, as there's no connection between the regulation, or there's not enough connection between the regulation, and there's even a contradiction between that and the statute. Now, that is my argument. I think it's a hunch, but that's not necessarily the winner, and I certainly don't control them. So John has an argument to say, well, Anthony, even if you're not right about that, even if they don't rule in your way, even if the U.S. Treasury does have the authority to create an FBAR regulation, what it can't do with that regulation is penalize anyone civilly. Is that correct?
I think that that's what I'm suggesting is the result under the existing statute, 5321. I mean, the authorization, the penalty rule is in 5321.
Yeah.
Clearly, as was added in 2004, and what 5321 says, okay, somebody who violates or causes a violation of 5314 has absolutely nothing whatsoever to do with any individual. It's a directive to Treasury to create the form.
Absolutely.
I mean, sure, this is a legislative failure, but it is what it is. And, I do not understand how, without a huge sort of leap in terms of what it means, they can get to this result. So, we have in Bittner, is the penalty base, or rather, I think the precise question is Treasury authorized to impose a penalty based on the number of accounts as opposed to the form? That's an interesting question. I think the answer is no, but that's just what I think. But I think there might be another question here. Well, there's two other questions. The first is, if you read 5321, whether they can impose a penalty at all.
Right.
And then, of course, there's the constitutional question where, I think somebody's trying to get the Supreme Court to hear the issue in the Toth case of whether the excessive fines clause in the Constitution would apply to this, or to put it another way, whether Treasury can claim that's exempt from the excessive fines clause because FBAR penalties are not fines, but they're rather penalties, right? Which seems to me to be.
Well, John, I think I'm wondering if we should maybe get together a brief on this to get this in there, because no one seems to really be bringing up this point that there's not, even if the regulation is allowed, you're not reading things correctly. And really, courts like to get, my experience is courts like to get rid of things as easy as possible. Every case usually wants to be the lowest common denominator is the way they like to resolve cases. So if a case can be resolved to say, oh, actually, we're not going to get into the excessive fines clause, we're not going to get into any of these things, because actually we're just looking at this and it's pretty simple. The statute isn't written that way. Okay. And then that could be the end of it.
Well, I think that the argument ought to be made. I mean, let's not kid ourselves. To take, so this Toth woman has what, $4 million or something, for them to just take $2 million away from her because she raised her hand and tried to comply with the law.
Yeah.
Seems to me, okay, no matter what you call it, pretty unreasonable. Okay. And I think that any and all ways that can restrict Treasury from this kind of conduct need to be explored. But, Anthony, I quite probably am completely wrong in my interpretation of this because I've never seen that point raised before. But it does strike me that if you actually read what the law says, I don't know, do you think that's a reasonable argument?
Well, look, I think that there's nothing I found wrong in your analysis, and what I always found, I think that the number, and you probably encountered this in law school too, is people just go with habit. They don't go with thinking. People don't want to think. People don't want to be the one to say, okay, here's my conclusion. Here's why. People always look for authority to hide behind because they don't want to defend their own thoughts. So as I look at this, it's like, no, this is probably the winner. This is probably the winning argument. And I think I really want to get some input from some of our staff and some of our followers.
Absolutely.
I think this is a winner in every which way, because it would allow the Supreme Court to get rid of a terrible case without impacting much law. There's a way for them to get rid of this. when every case will have precedent and unintended consequences. But if you say, well, look, this FBAR stuff we can take care of, and whatever your decision you're having won't impact anything else, and actually kind of makes things simpler, simply because if we just take a look at this to say, look, simple, the thing is criminal rights, and really, if you think about it, it makes sense that criminal violations could be regulatory. Well, if that's true, there's going to be a criminal trial, and you would assume like some level of due process. But here you're assessing remember, the FBAR is a criminal form. So you're trying to assess civil. So it would make a lot of sense that there wouldn't be civil penalties assessed on a criminal form unless there was some sort of due process of, say, a criminal trial place, that this wouldn't be, it makes sense that not only is the law written this way, but it actually makes sense that it would be written this way. It's not a mistake. They did not intend to civilly penalize any 5314 violations. That's very clear. If that's true, sorry, FBAR, you got to go away. And I think that's where we are. It's that simple. And I think I don't know how long we've been at it today, about 25 minutes on this. I think we've proven beyond a doubt the FBAR penalties don't exist, and it's completely.
Well, I don't know that I would go that far, but I would encourage you. My approach to this stuff is always I strive for as simple as possible. Okay.
Yeah.
I would encourage you to talk this up with people you're working with. I mean, I don't know. All right, but I mean, if you really, just to kind of close on this, if you look at what the damn thing actually says, it's not that easy to impose any penalty other than just making up a penalty.
Yeah.
They're going to do anything.
Yeah.
But I mean, and this is part of the problem with this whole FBAR stuff, right? Is that we have this unholy alliance, right, among the statute itself, the regulation itself, and the form itself, because the regulation, specifically says it includes the form. You got this unholy alliance, right? And the question is, at the very least, given the importance of this, you'd think this would be all written down in one place, right? But anyway.
Right, yeah.
All right.
Laws that are intended to. All right. Well, with that, thank you, John. Thank you so much. And yeah, we'd love to hear from you people, and cases developing. So be sure to stay tuned. Thanks again.